the deaths of Maggie and Paul. We are being joined now by Brian and Luke Shealy, two criminal defense attorneys, our legal experts who have been joining us over the last couple of weeks to get their take on what happened in court today. Let's begin with the gunshot residue cross-examination of Fletcher, the SLED agent, on the stand today. Any new details coming from that testimony we didn't already know yesterday, and was the defense able to debunk any of her testimony about the gunshot residue?
Well, yeah, I think the defense did a pretty good job. I mean, you know, the whole smoking gun, so to speak, from the state's perspective is this blue raincoat that, even though Ms. Smith said there was a tarp coming in the house from Mr. Murdaugh, they pulled a blue raincoat. It's got GSR heavily on the inside of it. So what that means is either, hypothetically, it could have been used to, you know, cover or carry in a weapon that had been fired a lot recently, or as defense lawyer Griffin said, you know, if the father of Mr. Murdaugh had been hunting, as he liked to do, and thrown a shotgun in the back of the trunk and thrown his raincoat on top, could that have accounted for it as well? Why, yes. So at the end of the day, this is a hunting family and a hunting county, lots of guns, and GSR doesn't just go away. It would have to be washed or wiped down, and so to have, you know, some GSR on a belt buckle or something of that nature really doesn't tie it in the way maybe the state wants to, but it's all another part of the piece of the puzzle that kind of you add up for a circumstantial case, at least as to the murders.
And really and truly, the science was spoken about by the agent, and there's not a real chronology to it. You know, there's a lot of testimony elicited from the agent that you can't really tell when GSR lands on something. You can kind of tell if it's really concentrated or if it's light, but in terms of when that GSR got there, you can't tell. Jim Griffin did a good job today of even saying there's, you know, been a lot of guns being held in this witness stand throughout the past 3 weeks, and would you be surprised to find there's GSR on your seat? And she said no, that would be, you know, readily accounted for. So it's a fascinating kind of line of science, but it doesn't really tell a lot other than there's a lot of GSR on that raincoat that still has not been attributed to Mr. Murdaugh, and certainly the defense is going to say that was not his raincoat.
I want to touch on the alleged financial crimes in this case. Brian, I believe you said last week and earlier this week, if these alleged financial crimes, if this testimony was allowed in, then it wasn't going to look too good for Murdaugh as far as going forward in this trial. But I believe you've got a different take on what's going to happen now, don't you?
JR, yeah. I mean, it's the more we see of the testimony from the financial witnesses, the financial malfeasance witnesses. We've had the law firm's CPA. We've had Mr. Gunn today. We've had the paralegal and others. You know, it's an overwhelming case against Mr. Murdaugh on the financial front. And, you know, when that came in, as criminal defense lawyers, Luke and I really wrestled with that legal ruling under the rules of evidence. But now that it's in, you know, we've kind of settled with that. And initially I was thinking he was going to have to assert the fifth, you know, not be speaking to that as he's being grilled on those issues. But now the more I think about it, it's going to have to be part of the story. He's going to have to, if his lawyers are preparing him the right way, and if his best defense, his only defense is, of course, I didn't do it, but let me tell you about who I think could have done it. He's going to have to explain the financial crimes in a way that tells a narrative that supports his defense. Where's all this money going? He's a wealthy man. He works for a firm where he makes a good living. Why is he stealing $2 million? Why is he acting this way? He's not spending on opioids. There's a bigger story here, and so I think his best defense now would likely be owning up to it. You know, these financial witnesses humanize him as well. Today, his paralegal was saying, yeah, he lied to me. My trust is gone. But at the same time, he's a good man. He would do anything for anybody. So that ties into it. He's going to have to raise his hand, admit to his wrongdoings, while at the same time explaining the possibility of who else could have done this, whether it's a criminal element associated with Cousin Eddie, whether it's something else he's aware of, but he's going to have to explain this money as why it could have ended in the killing of his beloved family.
Luke, do you agree with that assessment? Do you think it's going to be, okay, look, he may have done this and this and this, but he didn't kill his wife and his son?
I disagree with my brother partially. on the face of this overwhelming evidence of financial crimes and wrongdoing and years of lying to his close relatives, loved ones, coworkers, stealing money from his clients and his law firm, unless he's got some really unique theory that he can testify to and evidence can be put up, the evidence of these other crimes just buries him. Because even though whether it can really be said to be a true motive to distract the killings, to distract from his financial malfeasance, even if a jury says, I don't know if it's a motive, but man, he's just a bad guy, I think it gets buried. It gives it a legal question. We also heard some evidence of drug use today that's kind of just got put in there, an apology letter from rehab. But to Brian's point, it would have to be, Brian's pretty right about sniffing these things out, but the only way I can see him with all this evidence, the way the trial is shaping up to get off would be some type of like almost the TV show Ozark type thing where he got in over his head with a criminal element, maybe through some kind of drug using analysis, and then they just started working him and said, you're going to wash our money. You got tons of money coming through your family and your business. And then he would have to be able to prove that some terrible criminal element executed his family as a way to send a message or payback or something. But without something like that, I know that's all pie in the sky. Hollywood, he's going down.
Well, here's the other issue, JR. Just one last note on does he take the fifth or not? We've heard so much credible testimony from the financial witnesses. If he gets up there and says anything other than, you know what, they're right, I did wrong. And I'm thinking about the text message to his paralegal that was read in open court today. I did wrong. I want to rebuild relationships. You may not forgive me. I'm trying to be a better person. It's going to have to be along those lines, or else the jury will not suffer him trying to defend himself on those crimes. So I don't think he's going to take the fifth anymore. I think he's going to have to run it into a larger narrative of what happened, what possibly could have happened to result in the killing of his wife and son. But they're not going to buy any defenses there. His lawyer's going to have to be real smart in addressing those financial crimes.
So last week we learned in court that you can be tracked pretty much step by step with your cell phone. And today we learned in court that it took a little while, it took about a year or so, but they were able to crack the encryption on Murdaugh's vehicle, the Chevrolet Suburban, to try and track his movements on the night of the killings. More evidence, I guess, for the jury to consider about whether or not Murdaugh was there or not.
Right. It's heavy-duty technical data, and they're not taking notes, and it wasn't done in a very compelling fashion, but I imagine in closing it will all be tied up. But reading between the lines, the one thing it does is it does corroborate generally the evidence, the timeline. It certainly corroborates the caretaker, Mrs. Smith, where she was very certain in her in-trial testimony that he was there for 20 minutes. You sure it could have been longer? 20 minutes. And she got impeached a little bit. Previously, she'd said it was a little longer, 30, 40 minutes. So that matches her particularly well. Now, the pro-prosecution person in me might say, man, she's right on the money because that is the truth. But the cynical defense lawyer in me says, well, she did prepare for this trial, and I'm pretty sure the prosecution would let her know that other scientific data would also say that that he was there for 20 minutes. So that helps.
Brian, we've had so much thrown at this jury here. They've over the last couple of weeks, they've had the phone data thrown at them. Just in the last couple of days, the gun residue test, also the financial crime allegations, and then today, the information from his car. It's just a lot to absorb right now when it comes to this jury. How do you think they're doing and trying to process all of this right now?
JR, it's so difficult, and even in a shorter trial, for jurors to pay attention to the important stuff, to not get lost with red herring issues. And so here, there's been a major legal ruling where all the financial crimes get in as a motive. And, a lot of those witnesses are people that knew Alec Murdaugh. So, they're paying close attention to witnesses that had personal knowledge of the defendant that's on trial for 2 murders, just like Paul's friends. And so, but it's tough. They're not taking notes. They're not allowed to at this point. They haven't been allowed throughout the trial. They're going to have to, and that's why, I know the defense team has pulled the transcript of Miss Smith for either use in putting her back on the stand to correct some things that maybe they want to narrow down, or for use in closing. I know a lot of media, and I'm sure the jurors wish there was a timeline, a chronology of the times and when people were where, and both the defense and the state the closing will be so important in this case. And also what they get out through the summary witnesses, the lead investigator, Alec Murdaugh himself. They're going to have to get really organized, and you can use a lot of visual aids in closing that are in evidence, and that could be critical to how the defense and the state are organized in their presentation to the jury, because the jurors right now they're all over the place.
At some point in this trial, be it tomorrow or next week, or Friday, I should say, tomorrow, Friday, or next week, we're going to hear how Paul and Maggie Murdaugh died, aren't we? There's going to be witness testimony to that.
100%. It's going to happen. It's usually a very critical part of any murder case. The pathologist testifies from a very scientific perspective. Everybody knows that it's a gunshot wound that killed them, but it's going to be technical. With Paul, obviously, the way he was injured, it's very obvious. Maggie, maybe less so. And part of it is the state has a right to prove its case, but the other part is it is designed to produce kind of a compelling emotional response, because they get to prove their case, but the jury also gets to see some pretty graphic photos from, in part of the scientific perspective, that's just hard to ignore. And it might shed some light on distance, particularly of the shooter, stippling marks, what stippling will tell you about how far away they were.
Luke, do you want to explain what stippling is?
Yeah, stippling is basically what comes out of it's gunpowder that comes out of the end of a gun when it's being fired. And so you have very close range. If I were to shoot like that, it would be a lot of stippling or even a contact wound. And really from about 3 feet, you're going to have an intermediate range. Further distance, you're not going to have any. And so that will give you some idea. I think I read something that Mrs. Murdaugh has some measure of stippling on her somewhere. And I think that will be pretty interesting and helpful for the jury to figure out how far away her killer was.
And it's going to be interesting, Brian, I think, to see Alec Murdaugh's reaction when all of this is presented in court.
Yeah, I expect it'll be extremely emotional, just based on how his emotional response to talking to Paul's friends and seeing their testimony and people that were close to Paul and Maggie. He's been very emotional. So I imagine when that kind of testimony comes out about the exact nature and details of the death, likely he'll be emotional again.
So if all of the evidence that was presented in court today wasn't enough for you, a bomb threat comes in at around 12:30 today. Testimony is put on hold for 2.5 hours. So basically, I guess they took lunch a little early, extended the lunch break while authorities combed the courthouse. Just how bizarre. Is this something that happens frequently in high-profile cases?
Not too routinely. We've been in quite a few, and I think we did have a fire alarm at one point, but given that this has international attention, I'm sure that, number one, law enforcement will be trying to track in exactly who called, if they can, to charge somebody that would disrupt a court proceeding. But I don't know that we could speculate. We could speculate all day about who's got something to gain from pausing the proceedings, but it very well could be just somebody who knows most of America is watching and wants to disrupt what most of America is doing just for their own private yucks. So it's hard to say, but thankfully there was no bomb and they got back on track.
You agree with all of that?
I do, and it's unfortunate. Even with high-profile trials, you don't typically see stuff like this. I mean, we've seen disruptions in the courtroom. We've had trials ourselves where one party or another is angry and has an outburst in court that gets settled pretty quickly, but a delay like this that has disrupted the jurors' routine. I mean, every day they're eating lunch in isolation, not available to the general public, and all of a sudden they're, without any kind of reasoning, being kind of doing something different. And they're gonna know something's up.
Right.
Probably there could be some rumors in the courthouse, some mumblings about what actually occurred. And the most imperative thing is that they don't feel like their safety is in any kind of way at issue, because you want them to be able to focus, not feel like they have to rush to judgment They took an oath to do their job in a very fair and impartial way, and we just want to make sure that they are still focused and ready to do the job.
All right, Brian.